Igitondo cyiza ku badukurikiye kuri YouTube ya Kigali Today. Uyu munsi turi kwa gatanu, turi tariki 28 Gashyantare 2025. Uyu ni umunsi abanyarwanda bamaze igihe kinini bategereje cyane, aho mu rukiko rw'ubujurire cyangwa se urukiko rukuru rwa Nyamirambo rw'ubucuruzi hagiye kubera umwanzuro ku rubanza rw'umunyemari witwa Mironko aho yareze Leta y'u Rwanda kuba hari amafaranga itanishyuye agera kuri miliyari 18. Uyu munsi rero nibwo hagiye gusohoka umwanzuro kuri urwo rubanza. Nk'uko mubona aha turi mu rukiko, ariko abacamanza ntabwo barahagera bose, hari abatandukanye, ariko turi kumwe na avoka cyangwa se umwe mu bunganira mu mategeko Leta y'u Rwanda, uri kunganira mu mategeko Leta y'u Rwanda. Wenda icyo dushobora gukora, dushobora kumubaza akatubwira uko biteguye kuza kwakira umwanzuro wese biri buvemo, cyane ko mu rubanza mu mizi inshuro nyinshi zitandukanye uyu Mironko yagiye atsindwa, ariko aza kujya kugera ubwo aregamo mu zindi nkiko, ni naho yaje kurega, yaje kujurira mu rukiko rw'urubanza rukuru rwa EAC cyangwa se EACJ rw'umuryango wa Afurika y'Iburasirazuba. Nyuma yaho rero izimbere mu gihugu nko namaze kubivuga zagiye zanzura yuko uyu munyemari atsinzwe. Uyu munyemari rero yari yarareze Leta y'u Rwanda avuga yuko hari amafaranga yamwambuye ajyanye no kuba hari ibikorwa bitandukanye cyangwa se ibikoresho yayigurishije, ariko ntibaza kumwishyura. Ibi ni ibikoresho yaguze mu 1993, hagati ya 1993 ndetse n'94 byagarukaga ku bikoresho bya gisirikare. Wenda dushobora kuvugisha umunyamategeko uyu nguyu ni Maître Ntarugera Nicolas, dushobora kuvugana akatubwira uko kuri parti y'u Rwanda ese nk'umwunganizi mu mategeko bo babitekerezaho iki, wenda n'iki abivugaho. Mu kanya gato turakomeza. mu mategeko wunganira Leta y'u Rwanda muri uru rubanza rw'umunyemari Mironko François Xavier. Mwaramutse Maître Nicolas. Wenda turi kumwe n'abadukurikiye kuri YouTube channel ya Kigali Today, mushaka kutubwira ese urubanza rumaze igihe kinini, ni urubanza abanyarwanda biteguye, ese ni nk'iki nko kuri parti y'u Rwanda nkawe umaze igihe kinini muri uru rubanza, ushaka kuvuga uti abantu bakwiriye kwitega iki cyangwa se bigiye kugenda gutya?
Wakoze urubanza rw'urubanza rwatangiye mu 2018, rutangira muri First Division cyangwa se ruzitwa ku rw'ibanze rwo mu rukiko rwa South African Court of Justice. Of course binumvikana yuko iyo party imwe itsinzwe bafite uburenganzira bwo kujurira mu rundi rukiko, mu rukiko rwa Appellant Division. Nako byagenze rero. Uyu munsi niyo mpamvu muna turi muri Appellant Division cyangwa urukiko rw'ubujurire rwo mu rukiko. Niyo mpamvu rero hano kuko habaye kutishimira imikirize y'urubanza rwa mbere bagomba kuba kujurira. Mu rubanza mu by'ukuri mu kubyumva rwatangiye muri 2018 rutagiye mu rukiko, ariko bigaragara ko n'urubanza nyango rwahariye no mu zindi nkiko z'u Rwanda rwahereye kera, ariko particularly ahangaha turi mu rukiko rwaje muri 2018. Kuvuga rero kwitega ibiri ntabwo mbizi, twe turaburana nk'abunganizi mategeko cyangwa se ahagarariye ababuranyi, tukaburana mu gihe cyose utarasomerwa ntabwo mikiri bive mu rubanza.
Yego,
ntabwo icyo gihe ntabwo namikiri bivemo. Akazi kacu no kuba twakoze akaje tukaburana, tugategereza icyemezo cy'urukiko. Rero uyu munsi tuje gufata uyu munsi tuje gusomerwa.
Akenshi iyo habayeho ubujurire hari ubwo usanga nka parti ku ruhande wenda muhanganye mu rukiko cyangwa se mu rubanza, hari ubwo baba bafite ibimenyetso bishya. Ese muri uru rubanza rw'ubujurire haba hari ibimenyetso bishya kuri parti ya Mironko yaba yaragaragaje ku buryo mushobora kuvuga muti hari ibingibi byiyongereyemo? Kuko akenshi ni naho abantu bahera bavuga batoke impamvu tujuriye nubwo tutishimiye imikirize y'urubanza, ariko dufite n'ibimenyetso wenda bishya byari biri inyuma tugiye kugaragaza bishobora gutuma urubanza rugenda neza tukarutsinda.
Urubanza rwacirwanye mu nzonera ko by'ukuri habayeho kuburana, habaho gushaka gusubirishamo urubanza rwagize ntuze faza ndende cyane nyinshi cyane, habaye gusubirishamo nticyakirwa noneho asaba ataza gutanga n'ikirego gitanga mu gihe yakererewe ariko urukiko rumuhafiva rumwemerera yuko mu by'ukuri rumwemerera yuko agomba gutanga ubujurire burakirwa uyu munsi nibwo buranishwa kuvuga ngo ibimenyetso bishyashya by'ibimenyetso bisuzumwa n'urukiko yewe nkanjye mu pariti ndebe ibimenyetso byanjye natanze n'ibyo ngenderaho ariko ibyuriya bisuzumwa n'urukiko urukiko no gusoma ibimenyetso by'ababuranyi yewe mu by'ukuri ntacyo munsi dore nk'ikimenyetso bishyashya wenda ibyo byabwa n'urukiko nubwo bisuzuma rugakora analysis rukabisesengura rukabyemeza cyangwa rukabyemeza ko ari ibimenyetso cyangwa se ibimenyetso bishyashya rukabiha agaciro cyangwa n'ukabiha agaciro yewe icyo ntacyo nabivugaho rero by'ukuri
yego muci nikora murakoze cyane hanyuma rero mumaze kubyiyumvira nta bindi bidasanzwe reka tubwire abadukurikiye mukomeze mukurikire muze kumenya umwanzuro uri buze kuvamo uru rubanza. There is nothing special.
Yes.
You are just going to tell us your expectations.
Okay. Yeah.
Tugende? Uriho? Uru rubanza rero dutegerejemo urubanza rero dutegerejemo umwanzuro murabona ko habura amasegonda make cyane kugira ngo urukiko cyangwa se urubanza rutangire ariko twe tugize amahirwe yo kubona uwunganira Mironko uyu munyemari Mironko François Xavier le maître Claire Kituye. Can you tell us your expectation about this?
Okay, in as far as expectation for any legal process, you cannot really say, but what I know is we have made a good case for our clients.
Yes.
We have presented the facts very clearly, and we hope that the judges are going to take seriously our presentation, as well as those of our colleagues on the other side, and they're going to bring for the just judgment. I know it's a technical one, but we hope that justice is going to prevail.
Okay, in the beginning, you failed. So for this, do you have new facts that you can rely on?
We can't really say that we failed. There was just certain things that had not been considered before, and which we hope now that the courts, we presented before the court and they considered, is going to have a different outcome in the case.
Okay, thank you.
Thank you so much.
Murabyiyumviye rero nuko hari ibimenyetso bimwe na bimwe uruhande rwa Mironko cyangwa se uwunganira Mironko bavuga yuko bishobora kuba bitaritaweho. Reka tubareke mukurikire urubanza mwumve uko bimeze. Murakoze.
Coming up for delivery of judgment, Appeal number 8 of 2022, Mironko Francois Xavier versus the Attorney General of the Republic of Rwanda.
Yes, good morning, Council. Can we get introduction from the Attorney General?
Thank you, Judge President. My Lord Judge President, Your Lordships, my Ladyship, for the purpose of record, I'm Mr. Ntarugera Nicholas, Senior State Attorney, representing the Respondent, who is the Honorable Attorney General of the Republic of Rwanda. For the appellant, we have Mrs. Claire Kitui. She's present in court. My lords and your lordship, we are ready to receive the judgment. Thank you.
Thanks so much. We have come for delivery of the judgment in Mironko Francois Xavier, who is the appellant against the Attorney General of the Republic of Rwanda. Justice Sheborion.
Thank you, Judge President. This is an appeal from the judgment of the First Instance Division, the trial court, which sat at Arusha and was composed of Justice Yohana Masara, the PJ, Odwes Ngie, DPJ, Charles Nyachai, Richard Muhumuza, and Richard Wejuli, justices of that court. The judgment was dated 6th of April 2022 in reference number 11 of 2018. Introduction. Mironko Francis Xavier, the appellant, has preferred this appeal against the judgment of the trial court dated 6 April 2022 in reference number 11 of 2018. In the said judgment, the trial court dismissed the reference but directed each party to bear its own costs. The appellant is resident at Amanyabere village, Kimihurura Cell, Kimihurura sector, Gasambo district in the Republic of Rwanda, with his registered office in Nyarugenge district, Kigali city in the Republic of Rwanda. In this appeal, the appellant is represented by Mr. Joel Kimtai Bosek, an advocate, and Ms. Claire Namakagala Kitui, also an advocate. The respondent is the Attorney General of the Republic of Rwanda, a state party to the Treaty for the Establishment of the East Africa Community Treaty, and is represented in this appeal by Mr. Emily Ntwali, Principal State Attorney, and Mr. Nicholas Tarugera, Senior State Attorney. The background to the appeal. On 6 April 2022, the trial court dismissed the appellant's reference for having been filed out of time in terms of Article 32 of the treaty. The appellant was aggrieved by the judgment and lodged a notice of appeal on the 5th of May 2022 within the period of 30 days prescribed by Rule 88.2 of the East African Court of Justice Rules of Procedure 2019, and served the notice of appeal upon the respondent on the 10th of May 2022. That was within the 14 days prescribed by Rule 89 of the rules. The reference to the trial court. On the 4th of June 2018, the appellant filed reference number 11 of 2018 in the trial court against the respondent under Articles 6A, 9, 23, 27, and 30 of the treaty. Also under Articles 2 and 60 of the African Charter on Human and People's Rights, and Rules 8.1 to 6, 21, 1, 2, and 3 of the East African Court of Justice Rules of Procedure 2019, alleging violation by the respondent of her obligations under the treaty, specifically Articles 6D, and 7.2 thereof. However, the respondent denied the violation of the treaty alleged in the reference. It was the appellant's case that sometime in 1993 and 1994, through a public tendering process, he was awarded a tender by the respondent to supply various military equipment, which he did supply, but due to the confidential character of the procurement, the urgency of the tender, and from the exceptional circumstances that the country was experiencing, the tender was awarded on a mutual agreement between both parties, as provided by the law. The appellant claimed that following certain payments made by the respondent, there remained an unpaid balance in respect of the delivered goods amounting to 7,100,000 Belgian francs. The appellant unsuccessfully lodged a number of cases in various courts of judicature of the respondent up to the Supreme Court, which on the 6th of April 2017 declined to entertain a review on the basis that the new evidence alleged by the appellant did not meet the threshold to justify a review in accordance with the applicable law of the respondent. Further, the appellant approached the Ombudsman requesting for a review of the Supreme Court's decision on the basis of an injustice caused to him, but the Ombudsman declined to grant him such a request through its decision delivered on the 24th of April 2018. Thereafter, the appellant filed reference number 11 of 2018 in the trial court against the respondent, seeking for the following reliefs. First, a declaration that the government of Rwanda violated Articles 6D and 7.2 of the treaty, its national laws, international conventions, as well as the general principles of law. Secondly, a declaration that the government of Rwanda committed injustice against him. Thirdly, an order that the government of Rwanda reestablishes the appellant in his rights. And lastly, for any reliefs as this honorable court may deem just to grant. The respondent denied all the allegations made by the appellant, arguing that the appellant, having chosen to approach the courts of Rwanda, the judicial system provided him a fair and just process, but was not able to prove his claims. The respondent further argued that the appellant approached this court on a disguised appeal as a reference, and that the reference was not a case for interpretation or application of the treaty, but an invitation to this court to sit in an appellant capacity over the decision of Rwanda's Supreme Court and that of the Ombudsman. The respondent further contended that the reference was, in any event, time-barred and could not be entertained by this court in exercise of its jurisdiction under the treaty, and that the reference did not disclose any cause of action. The respondent prayed the trial court to dismiss the reference with costs. The scheduling of the conference, hearing of the reference, and decision of the trial court. At the scheduling conference held by video link on the 3rd of July 2020, before the trial court, the following issues were framed for determination, namely, whether the reference is time-barred. Secondly, whether this court has jurisdiction to entertain the reference. Third, whether the acts complained of by the applicant constitute a violation of Articles 6D and 7.2 of the treaty for the establishment of the East African Community, and whether the parties are entitled to the remedies sought. After hearing the parties, all the evidence adduced, and upon considering the relevant jurisprudence, the trial court, by its judgment dated 6 April 2018, which is impugned in this appeal, held that it lacked jurisdiction rational personae, that is locus standi, and jurisdiction rationale material to entertain the reference, and also that the reference, having been filed out of time in terms of Article 32 of the treaty, the court lacks jurisdiction rational temporis to hear and determine the same. Accordingly, having found that it did not have jurisdiction in the matter, the trial court downed its tools and declined to determine any other issues. The ultimate result was, as we have already pointed out, that the trial court dismissed the reference but directed each party to bear its own costs. The appeal. The appellant was aggrieved by the judgment of the trial court and lodged a notice of appeal on the 5th of May 2022, followed by a record of appeal dated 9th of June 2022. The appellant raised a multitude of grounds of appeal, 14 in number, in its memorandum of appeal, which we deem necessary to reproduce here in verbatim, namely that the Honorable Judges of the First Instance Division add in law and fact in dismissing the reference without considering and determining the issues in the reference on merit. The Honorable Judges of the First Instance Division add in law and in fact in interpreting of the limitation of time to bring this reference and holding that the reference was time-barred, whereas the cause of action accrued within the time of lodging the reference. The Honorable Judges of the First Incident Division add in law and in fact in abdicating its jurisdiction and being reluctant to fault the trial court in dismissing an application for review at the Supreme Court of Rwanda without considering the application on its merits, hence denying the appellant access to justice. The Honorable Judges of the First Instance Division add in law in finding that its jurisdiction of judicial review should draw a distinction between organs of state. The treaty does not distinguish organs of state and does not separate whether they are judicial or non-judicial. The Honorable Judges of the First Instance Division add in law in failing to appreciate that its jurisdiction extended to questioning the judicial decisions of national courts and that such courts are, as per the treaty, regarded as organs of state. The Honorable Judges of the First Instance Division add in law in not appreciating a very basic principle of the rule of law in considering the matter in which proceedings were carried out in the municipal courts and whether they complied with the standards of rule of law envisaged by the treaty. The Honorable Judges of the First Instance Division add in law and in fact in failing to appreciate the legal provisions that allow for consideration of new evidence by trial courts, if such evidence has come to the knowledge of the court and has a bearing on the direction of the court and has a bearing on the direction that the court would take in a matter for a just determination of the case. The Honorable Judges of the First Instance Division add in law and in fact by failing to consider the entirety of the evidence tendered by the appellant in the trial courts as proof of supply of military equipment to the state, and instead requiring the appellant to provide other evidence which is not part of the appellant's bundle of documents. The Honorable Judges of the First Instance Division add in law and in fact in ignoring the express provisions of the Rwandan law on admission of new evidence. The Honorable Judges of the First Instance Division add in law in failing to appreciate that the appellant was denied the right to due process of law in that A, the court disregarded and denied evidence which was produced by the appellant in the course of the trial. B, the evidence produced by the appellant during trial was not controverted by the respondent during cross-examination or defense, or in the defense case, yet the court upheld the appeal by the higher courts. C, the Supreme Court and the Ombudsman denied the appellant the right of review of the decision of the Supreme Court. The Honorable Judges of the First Instance Division add in law and in fact in not finding that the trial court was clearly biased against the appellant's submissions and protestations and failed to allow his mind to be guided by principles of fairness and a due process of law. The Honorable Judges of the First Instance Division failed to appreciate the validity and veracity of evidence which clearly favored the appellant herein. The Honorable Judges of the First Instance Division add in law in not finding that the respondent herein had failed to act in accordance with the principles of good governance, including adherence to the principles of rule of law and the maintenance of universally accepted standards of human rights. The Honorable Judges of the First Instance Division add in law in not finding that the claim for special damages had not been controverted and or contradicted by the respondent, and hence the appellant herein was entitled to the same. The appellant also prayed that the court grant the following orders. First, that the judgment entered by the Honorable Judges of the First Instance Division on 6 April 2018 be and is hereby set aside. 2, a declaration that the dismissal of the appellant's case without looking at its merits contravene the provisions of Article 6D and 7.2 of the Treaty for the Establishment of the East African Community. And thirdly, a declaration that refusal to entertain the application for review violated the principles of Article 6D and 7.2 of the EAC Treaty, particularly on the rule of law. And 4, a declaration that the appellant is entitled to his claim as per the decision of the Honorable Judges of the First Instance Division that awarded him as claimed. 5, a declaration that the appellant is entitled to damages. And 6, costs of this appeal and the one at the Honorable Judges of the First Instance Division be awarded to the appellant. On the 12th of August 2022, the respondent filed application number 12 of 2022, seeking to strike out the appellant's notice of appeal on the ground that the appellant had failed to take essential steps within the prescribed time. At the scheduling conference for the appeal held on the 15th of August 2022, the parties agreed on 3 issues for determination by the court, with issue number 1 being whether the appellant's appeal was properly before the court, and on that basis, the respondent withdrew its application to strike out the appellant's notice of appeal. When the appeal was called up for hearing on the 23rd of November 2022 in Kampala, in the Republic of Uganda, the appellant applied informally for extension of time to deem the appeal as having been filed within time. The court drew the appellant's attention to the fact that under Rule 94 of the rules, the kind of application he was contemplating must be made formally, at which point the appellant successfully applied for an adjournment to consider his position. Subsequently, on the 7th of December 2022, the appellant filed application number 15 of 2022 for extension of time and to deem appeal number 8 of 2022 as filed on time. That application was heard and allowed via a ruling of this court dated 27th February 2023. The court deemed the record of appeal filed on 9th of June 2022 to have been filed on time. That ruling effectively disposed of the first issue in the appeal, namely whether the appeal was properly before the court. Back to the appeal. This appeal came up for hearing on the 23rd of February 2024 for the parties to submit on the following 2 issues. First, whether the Honorable Judges of the First Instance Division erred in law by determining that the court lacked jurisdiction to entertain the reference. And 2, whether the parties are entitled to remedies sought.
Yeah, thank you so much, Justice Borian. I think Justice Makungu, you can proceed.
Submission by the parties on the issues. Issue number 1, whether the First Instance Division erred in law, the appellant reference number 8 of 2022 was time-barred. The appellant's submissions. Before making his submission on the issue as framed by the parties with the assistance of the court, counsel for the appellant made a summary of the background of the appeal, which we find no reason to reproduce here because it is a repetition of what is contained in the memorandum of appeal. On the issue as to whether the trial court erred in law by determining that the court lacked jurisdiction to entertain the reference, counsel gave a factual background to his grievance that emanate from a tendering process, which was awarded to 2 of the appellant's companies. 1, the International Industries SA, based in Belgium, and 2nd, Mironko Euroafric SP RL based in Luxembourg. Surprisingly, the appellant does not indicate in this factual background when the tender was entered into. It was argued by counsel that the appellant lodged a number of cases and complaints in various organs of the respondent, from the Commercial Court of Nyarugenge to the Commercial High Court up to the Supreme Court, where its case was dismissed. He made a further appeal for review in the Supreme Court, and the same was declined. We note also that even for this chronology of cases in the courts of judicature of the respondent, the appellant does not indicate which years, months, or dates these cases were filed or decided by the courts of law. He further submitted that after all his complaints were dismissed up to the Supreme Court, he approached the Ombudsman, who on 24th April 2018 declined to entertain the request that the Supreme Court do review his case on fresh evidence. It was argued that the particular action of the Ombudsman not to even entertain his request to have the matter reviewed brought him to the full awareness of the fact that the state organs, namely the court and the Ombudsman, were bent on frustrating his claim with a view of refusing to pay him what they owed him. Counsel submitted that following the refusal of the courts and the Ombudsman to pay what they owed him, the appellant proceeded to file the reference for the court to determine whether the respondent's action of refusing to honor an obligation it owed to him was in line with the provision of the Treaty on the Principle of Good Governance. Counsel argued in paragraph 15 of his submission that as far as the main issue of claim of debts is concerned, the issue of limitation of time does not arise. In the same paragraph, the appellant submitted that in any event, the treaty does not have jurisdiction to entertain the matter of a debt owed to an individual and was thus not with the ambit of the court. That, however, the general conduct of the respondent as regards the issue of the debt owed to the appellant and the process involved revealed another cause of action which fell within the scope and jurisdiction of this court, that is, lack of good governance on the part of a state that does not honor an obligation owed to its subject, and that this culminated in the blatant and deliberate refusal of the Ombudsman to entertain a materials application for review, displaying a blatant disregard for the claim by the appellant, which occasioned a cause of action to accrue. Counsel submitted further that the statute of limitation follows the maxim equity does not aid the indolent, which is a weapon used to fight an indolent litigant who does not want to act on his claim until it is too late in the day. He cited Gathoni versus Kenya Cooperative Creameries Limited, 1982 KLR 104, where Peter J.A. stated the rationale of the law of limitation as follows. The law of limitation of actions is intended to protect defendants against unreasonable delay in bringing of suits against them. The statute expects the intending plaintiff to exercise reasonable diligence and to take a reasonable step in his own interest. That further in Rawal versus Rawal, 1990, KLR 275, the court held as follows. The object of any limitation enactment is to prevent a plaintiff from prosecuting stale claims on the one hand, and on the other hand, protect a defendant after he had lost evidence for his defense from being disturbed after a long lapse of time. It was counsel's further submission that the appellant could not be said to have been indolent, taking into account the several efforts he made to achieve the elusive justice that he was denied by the respondent's organs, first by filing his claim in the commercial court at Nyarugenge, and the subsequent appeals up to the Supreme Court, which in a sense means the matter was under active litigation and not redundant. He further submitted that the reference before the trial court was lodged on 4th June 2018 before the expiry of 2 months after the decision of the Ombudsman delivered on 24th April 2018. In paragraph 21 of his written submission, the appellant argues that this court has jurisdiction to review the action of all organs of state, which might come in form of decisions, directions, or orders, and that the jurisdiction of this court covers both judicial and other state organs. He further submitted that the trial court did not pronounce itself on how all the state organs entertained this matter, but gave only emphasis on the doctrine of jurisdiction rationale temporis, and shut out all other equally critical issues. The appellant's assertion is that his claim is not for the debt owed, but for the breach of the principle of good governance by the respondent to honor its obligation to him, compounded upon receiving the letter from the Ombudsman rejecting his request. It was counsel's argument that the starting date is in relation to the act or decision taken to appeal the decision of the commercial court. The reference filed on 16 June 2018 is ostensibly outside the 60 days limitation in which to file a reference. That, however, it is his submission that the starting date in the reference is the date when the Ombudsman summarily declined to address his application for review, and that when the decision of the Ombudsman was communicated to him. The appellant submits in paragraph 30, Roman 4, that the trial court ignored the series of decisions by a number of organs of the respondents: A, the commercial court at Nyarugenge; B, the Supreme Court; and C, the Ombudsman, as decisions that this court has jurisdiction to review. Counsel relied on the decision in Martha Wangari Karua versus Attorney General of the Republic of Kenya, reference number 20 of 2019, wherein the trial court quoted with approval the decision in East African Civil Society Organization Forum versus Attorney General of the Republic of Burundi and others, reference number 2 of 2015, in the following terms. The reference before the trial court was not a further appeal from the decision of the Constitutional Court of Burundi. It was a reference on the Republic of Burundi international responsibility under international law and the East African community attributable to it by reason of an action of one of its organs, namely the Constitutional Court of Burundi. The trial court had a duty to determine this international responsibility, and in so doing, it had a further duty to consider the internal laws of the partner state and apply its own appreciation thereof to the provision of the treaty. Finally, on this issue of time limitation, counsel submitted that the grounds relating to dismissal of the reference, basis of lack of jurisdiction temporis, does not. Counsel made long submissions on the respondent owing the appellant liabilities, but we find no meaningful reason at this juncture to spend a minute of time or reproducing a single word of the submission thereof, because that was not identified as an issue for determination in the scheduling conference or at any time during the proceeding of this appeal. Respondent's submissions. Before submitting on the issue as to whether the trial court erred in law in dismissing the reference for being time-barred, counsel for the respondent made long submission that his appeal is not properly before this reasonable court. Counsel argued that it appeared from the appellant memorandum of appeal that his sole preoccupation was to have the appellate division rehear and determine afresh the question of fact and law examined by the trial court in reference number 8 of 2018. However, this is a matter to be discovered by the court after analyzing the whole proceeding and submission by the parties on the very issue on lack of jurisdiction as framed by the parties and is provided for under Article 35A of the treaty. Coming back to the main issue as to whether the judges of the first instance division erred in law in dismissing the reference for lack of jurisdiction rational temporis, the respondent made short and brief submission that the trial court correctly decided that the reference was filed well beyond the time limit set out in Article 32 of the treaty, and that the appellant was irredeemably out of time, and as a result, the court lacked jurisdiction rational temporis to hear and determine the reference. It was counsel further contention that the trial court did not violate any provision of the treaty of the rules by dismissing the reference without determining the issue therein on merit, given that the reference was time-barred. The respondent therefore prayed that the appeal should be dismissed with cost. Appellant's reply to the respondent's submission. Counsel argued that it is true that in the scheduling conference held on 15th August 2022, the first issue was whether this appeal is properly before the court. But the central issue in the appeal is the question of whether the court erred in determining that it lacks jurisdiction temporis to determine the appeal. It was further argued that with the issue of jurisdiction being the central issue of determination, it is quite apparent that the appeal meets the condition for an appeal both under the treaty and the rules, and that the respondent in his submission has not demonstrated otherwise. Counsel strongly contended further that it is noteworthy that the respondent has extensively submitted on the threshold for an appeal tackling procedural irregularity and error or mistake when the appeal basically lies on the question of jurisdiction.
Thank you. I think you can stop there. Please, Kathulima, can you proceed?
Thank you, Judge President. We continue with the reading of the judgment. The court's determination of the first issue. Before we tackle the very issue before us as to whether the trial court erred in law in dismissing reference number 11 of 2018 for having been found out of time contrary to the provisions of Article 32 of the treaty, we think it is imperative to say a word on the argument by counsel for the respondent that this appeal is not properly before the court. In a sense, the appeals to this court are governed by the provisions of Article 35A of the treaty, which provides that, quote, an appeal from the judgment or order of the trial court shall lie to the appellate division on A, point of law, B, grounds of lack of jurisdiction, or C, procedural irregularity. In Simon Peter Ochieng and others versus Attorney General of the Republic of Uganda, EACJ Appeal number 5 of 2015, where the court in its judgment raised the question of the propriety of an appeal for determination before it, it was held that the appellant must establish either a point of law, lack of jurisdiction, or procedural irregularity. The central issue before us, therefore, as has been clearly underlined by and argued by counsel for the appellant in their written and oral submissions, is whether the trial court erred in law in determining and holding that it lacked jurisdiction lacune temporis over the reference for having been found out of the 2 months provided for under Article 32 of the treaty. For avoidance of doubt, we deem it necessary to reproduce Article 32, which provides as follows, quote, the proceedings provided for in this article shall be instituted within 2 months of the enactment, publication, directive, decision, or action complained of, or in the absence thereof, of the day in which it came to the knowledge of the complainant, as the case may be, end of quotes. In a sense, and considering the whole proceedings, submissions, and arguments from the parties, the central issue before us at this juncture is an issue that relates to lack of jurisdiction of the trial court, which is a ground of appeal under Article 35A of the treaty and Rule 86 of the rules, and as explained in Simon Peter Ochieng and others versus Attorney General of the Republic of Uganda. The issue of procedural irregularity has been invoked at strength by counsel for written submissions and oral submissions is not relevant, especially after the ruling of this court rendered and delivered on 27th February 2023 in application number 15 of 2022 at paragraph 30 and 31 of the ruling. This court held that, quote, we are accordingly satisfied that at this stage we cannot say that the applicant's appeal is not arguable. Taking all the above into account, and in particular the circumstances of this appeal, we are satisfied that the applicant's application for extension of time is merited, and we accordingly allow the same and deem the record of appeal dated 9th June 2022 filed on time. End of quotes. With due respect to counsel for the respondent, the central issue before us is whether the trial court erred in law in holding that it lacked a jurisdiction lacune temporis to hear the reference, which according to the court, unsupported by counsel for the respondent, was filed out of the time of 2 months provided for under Article 32 of the treaty. It is also upon the appellant to prove how the trial court made the error as contended by counsel for the appellant. We make reference to Simon Peter Ochieng again in paragraph 29, which reiterated that, quote, he who alleges must prove. In that regard, party alleging whatever error must explain what the alleged error is and how it leads to miscarriage of justice. Equally, in the instant appeal, it is up to the appellant who is alleging an error of law occasioned by the trial court to identify, establish, and explain the alleged error of law and how it invalidates the impugned decision. End of quotes. This court, being the court of final resort, has reiterated in its judgments and even during the hearing and submissions by the parties that the Supreme Court of Justice and International Court established by the Treaty, Article 9, the judicial body of the community mandated to ensure adherence to the law in interpretation and application of and compliance with the treaty, Article 23, and whoever appears before it or submits before it needs and must understand the nature and character of the court. Also, from the provisions of Article 35A of the treaty and Rule 86 of the rules, litigants need to understand that this court is not a court of appeal over judgments and all decisions of national judiciaries, unlike the defunct East African Court of Appeal. In determining the first issue, it is necessary to recall the history of the litigation in the respondent, reading to the reference. Back in 1993 and 1994, through a public tendering process, the appellant was awarded a tender by the respondent state to supply various military equipment. The appellant filed a number of complaints in the courts of judicature of the respondent from the Commercial High Court up to the Supreme Court, and the latter declined to entertain a review, and its final decision was delivered on 6 April 2017 as per paragraph 16 of the impugned judgment of the trial court. The appellant approached the Ombudsman requesting for a review of the decision of the Supreme Court, and the request was declined by the Ombudsman by his letter delivered on 24 April 2018 as per paragraph 17 of the impugned judgment of the trial court. Now, it is in the imperative function of this court to find out what action or omission the appellant has complained of as constituting violation of the treaty, and therefore justicia will be for the court in implement 23(1) of the treaty. In Democratic Party versus Secretary General of the East Africa Community and others, EACJ reference number 20 of 2012, this court held that, quote, once a party has invoked certain relevant provisions of the treaty and alleges infringement thereof, it is incumbent upon the court to seize the matter and entertain its jurisdiction and Article 23, 27, and 30 to determine whether the claim has merit or not, end of quote. This, of course, is done subject to the provisions of Article 32 on time limitation, which is the issue under analysis here. From the pleadings of the parties in the national judiciaries of the respondent, starting from the Commercial Court in Nyarugenge to the Supreme Court, which is the highest court of judicature of the respondent, the appellant's claim related to failure by the respondent to pay him a debt ostensibly arising from the supply of military equipment in 1993 and 1994. The final judgment of the Supreme Court was delivered on 6 April 2017. It seems that after the appellant failed to get the claimed debt from the judicial system of the respondent, he approached the Ombudsman, who also declined by the letter dated 24 April 2018 the request for review of the decision of the Supreme Court. It was after the appellant was notified of the decision of the Ombudsman that he filed on 4th June 18, reference number 11 of 2018. The question that the court should ask is whether from the pleadings the appellant was really aggrieved by the decision or omission of the Ombudsman of 24 April 2018 or the failure of the respondent's organ's institution to honor payment of his claimed debt. This court has been very careful when it is called upon to interpret the provisions of Article 32 of the Treaty on the time required to access the court in order to avoid legal uncertainty and confusion, not only to the actual and future litigants, but also to the partner states, to organs and institutions of the East African community, and most importantly, to the implementation of the agenda of the community. For instance, in Bogo Murithi Wanyambura versus Attorney General of the Republic of Kenya, EACJ reference number 11 of 2011, this court held that the general rule of interpretation set out by the Vienna Convention on the law of treaties is applicable to the interpretation of this article. It is our understanding from the plain reading of Article 32 that a reference charging any unlawfulness or infringement provided for under Article 31 must be instituted within a period of 2 months of the occurrence or in the absence thereof, when the complainant came to know the act or action complained of. This is the clear and honorary meaning to be given to Article 32, end of quotes. This court also observed in Attorney General of the Republic of Uganda and the Attorney General of the Republic of Kenya versus Omar Awadh and 6 others, EACJ Appeal number 2 of 2012 as follows. Quote, the court is still of the same view that the objective of Article 32 is legal certainty. It still notes that the purpose of this amended provision of the treaty was to secure and uphold the principle of legal certainty, which requires a complainant to launch a reference in the East African Court of Justice within the relatively brief time of only 2 months. Nowhere does the treaty provide for any exception to the 2 months period. Therein lies the critical difference between the East African Community Treaty, which governs trade matters as the objective of cooperation between the partner states on the one hand, and on the other hand, human rights conventions and treaties which provide exceptions for continuing violations on the ground that securing the fundamental rights of the citizens is of paramount essence. For this reason, the judicial bodies that have human rights jurisdiction must strenuously uphold and protect all such rights through a liberal and purposive interpretation. End of quote. The court also held that, quote, it is clear that both the context and intent of Article 32 provides a legal framework for determining the starting date of an act complained of, or alternatively, the date on which the complainant first acquired the requisite knowledge, or with the objective of ascertaining the commencement and expiry of the time of the 2 months. In that spirit, the article does not contemplate the concept of continuing breach or violation inasmuch as the acts complained of or the time when a claimant had knowledge of the breach of infringement have definitive starting dates and expiry within the 2 month period. The only continuing period envisaged under the article is the grace period implicitly allowed under the second limb of that article for the complainant to have knowledge of the act. From the date of such knowledge, the legal clock for the 2 month period starts to tick. End of quote.
Yeah, that's okay. The Vice President, you can continue.
Thank you, Judge President. The reading continues as follows. An important follow-up question here is, 1. Which date has the legal clock for the 2 months period started to tick as regard to the filing of the reference in the first instance division? 2. Was it after the appellant received the letter from the ombudsman or after he became aware of the respondent's state's failure to pay him his claim date long before the filing of the reference? The only answer to the 2 similar questions is that the legal clock started to tick for a period of not more than 2 months provided for under Article 32 of the treaty, when the appellant became aware that the respondent state was unwilling to pay him his claim date by the commercial court up the Supreme Court on 6 April 2017, and this was long before the Ombudsman letter of 4th June 2018. Counsel for the appellant tried to underline in paragraph 24 of their written submissions that the appellant's assertion is that his claim is not for the debt owed, but for the breach of the principles of good governance by the state to honor its obligation to him, compounded upon receiving the letter from the Ombudsman rejecting his request. However, counsel for the appellant in paragraph 35 of their written submissions states that the appellant properly says the jurisdiction of this honorable court by lodging reference against the decisions of the respondent states organs, ombudsman included. From the appellant's own assertion, his grievances are clearly not caused by the ombudsman's action or omission only, but also by other organs of state. The ombudsman only included to those other state organs that failed to pay him his claimed debt following alleged supplies of military equipment way back in the years 1994 and 1993 and 1994. This also corroborated from the appellant's own argument in paragraph 36 of his written submission that the failure by the respondent to pay full amount for goods supplied by him was in the violation of Article 60D and 7.2 of the treaty. Counsel further argued in paragraph 38 that non-payment on the part of the Republic of Rwanda, rather than the letter of the Ombudsman, denied the appellant his rightful earnings. In Arcon International Limited versus Standard Chartered Bank of Uganda and two others, EACJ Appeal number 3 of 2013, the court reiterated that under the treaty, a reference must be filed within 2 months of the crystallization of the cause of action or knowledge by the claimant of the existence of the cause of action. From the foregoing, we are not persuaded that reference was filed within the prescribed of 2 months provided for under Article 32 of the treaty. The cause of action in the reference arose not following the letter of the Ombudsman, but after the decisions of the national judiciaries of the respondent. We bear in mind from the laws of the respondent, the Ombudsman had power over the Supreme Court of Rwanda. In Angela Amudo versus Secretary General of the East African Community, East African Court of Justice Appeal number 4 of 2014, this court cited with approval the decision of the Privy Council in Muhammad Hafiz versus Muhammad Zakaria that the cause of action is what gives occasion for and forms the foundation of the suit. End of quote. The court further explained that any claim or suit, be it in tort, contract, etc., must always be based on a cause of action, and that cause of action is the reason or basis for which a suit or claim is brought. Similarly, in Aba Limited versus Attorney General of the Republic of Rwanda, EACJ Appeal number 10 of 2022, at paragraph 40, this court observed as follows. The court, in the present appeal, the trial court carefully considered the appellant's pleadings and concluded, rightly in our view, that the real cause of action is pleaded by the appellant was the alleged violation of the treaty by what he considered to be the illegal and unlawful revocation of the district council of the agreement for the sale of the market. The trial court observed as follows. Whereas the applicant broadly contended that his cause of action arises from the decision of the Ombudsman in paragraph 23 of the reference, the applicant seeks for the solution of the decision revoking the sale agreement and for award of compensation to ABBA Limited by the District of Rubavu due to their alleged illegal decision. It is discernible from this very paragraph that the offending act for which the applicant seeks relief is indeed the revocation of the sale agreement of the Gisenyi Modern Market by the Mayor of Rubavu, and further that the compensation sought is to be exclusively realized from the District of Rubavu on account of their alleged illegal decisions. End of quote. At paragraph 41, the court concluded that, I quote, having carefully considered the record, it is sufficient clear from the statement of claim and the appellant submission both before this court and the trial courts that the government of its claim is the alleged violation of the treaty by what it considered to be the illegal revocation of the sale of the market to it. The express and unequivocal relief that the appellant sought in the statement of a claim are restoration of the revoked agreement for sale of the market or compensation. Such reliefs are directed at the decision of the district council rather than at the decision of the ombudsman. Accordingly, from the appellant's own pleading rather than from its submission and assertion, we agree with the trial court that time for purposes of Article 32 of the treaty was to be reckoned from the date of the cancellation of the agreement for the sale, namely 25th June 2015. For that reason, the appellant's reference number 18 of 2018, which was lodged on 1st August 2018, was time-barred, and the trial court did not have jurisdiction to entertain it. We are therefore...
Let me proceed. We are therefore, from the reasoning clearly underlined in the above paragraphs, and from the submissions by the parties, both in their written and oral submissions, unequivocally satisfied that the reference number 11 of 2018, which is the subject of the impugned judgment delivered on 6th April 2022, was filed out of time, limitation of 2 months, required under Article 30, sub 2 of the treaty, as heard by the trial court. Being that the trial to entertain the reference, which was time barred due to lack of jurisdiction, ratione temporis. Without jurisdiction, the court downs its tools. The court also held in the Attorney General of the United Republic of Tanzania versus the African Network for Animal Welfare, EACJ, Appeal number 3 of 2011, that, I quote, jurisdiction is a must, if not the most fundamental issue that the court faces in any trial. It is the very foundation upon which the judicial edifice is constructed, the fountain from which springs the flow of the judicial process. Without jurisdiction, a court cannot even take the proverbial first Chinese step in its judicial journey to hear and dispose of the case. This court also extensively dealt with the conceptualization of jurisdiction for purposes of the adjudication of cases in EACJ in Arcon International Limited versus the Attorney General of the Republic of Uganda and the others, EACJ Appeal number 3 of 2013. Suffice to say that the court noted that the word jurisdiction is used as a unitary concept to denote 3 essential elements which enable the court to operate, namely jurisdiction ratione material, which is subject matter, jurisdiction ratione persone, which means the locus standi, and jurisdiction ratione temporis, which is the temporal condition. The absence of any of the above essential elements of jurisdiction would disavow this court the mandate to entertain a dispute. The jurisdictional element in question in the trial court was whether the appellant had complied with temporal condition of 2 months provided for under Article 30, sub 2 of the treaty to institute a reference in this court. From our scrutiny of the whole record of the trial court, the submissions by the parties, the authorities, and jurisprudence available, it is crystal clear that the reference was time-barred, and as a consequence, the trial court did not err in holding that it does not have jurisdiction, ratione temporis, to entertain the reference. Therefore, issue number 1 is answered in the negative. Before we take leave of this issue, it is very important to make our observations to the averments by the counsel of the appellant in paragraph 10 of his written submissions that the appellant proceeded to file the reference for the court to determine whether the state's action of refusing to honor an obligation it owed to him was in line with the provision of the treaty on the principle of good governance. Counsel also argued in paragraph 39 of the written submission that the trial court failed to appreciate the centrality of the principles of good governance and rule of law in financial transactions, which is intended to promote the free movement, free market economy. In Baranzira Rafael and another, versus the Attorney General of the Republic of Burundi, EACJ reference number 15 of 2014, this court examined the concept of rule of law, quoting from a UN report. The court stated that, I quote, the concept of rule of law refers to the principle of good governance to which all persons, institutions, and entities, public or private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights norms and standards. It requires as well measures to ensure adherence to the principle of supremacy of the law, equality before the law, accountability to the law, fairness in the application of the law, separation of powers, participation in decision-making, legally certainty, avoidance of arbitrariness, and procedural and legal transparency. End of quote. It must also be appreciated that this court does not have the mandate outside that is provided for under Article 23(1), 27, and the 31 and 2 of the treaty to engage with issue of good governance and the rule of law without jurisdiction, ratione temporis. The court cannot arbitrarily assume and determine issues of good governance and the rule of law. The issue number 2 on remedies. The appellant urged the court to grant him the remedies set out in paragraph 16 of the judgment and to award him costs of the reference and of his appeal, of this appeal. On the other hand, the respondent submitted that the appellant is not entitled to any remedies and prayed that the appeal be dismissed with costs. Having answered issue number 1 in the negative, all the reliefs sought by the appellant is captured in paragraph 16 of this judgment are unavailable. This court has no basis to make any order as prayed by the appellant once it finds that the reference was time-barred and that the trial court did not err in declining to determine the same for lack of jurisdiction. In other words, the appellant is not entitled to any of the remedies sought. In Abba Limited, the Attorney General of the Republic of Rwanda, Supra, while considering this issue of remedies, which was similar to this appeal, this court held as follows. I quote, we have answered issue number 1 in the negative, meaning that the trial court did not err when it held that the appellant's reference number 18 of 2018 was time-barred and that the court did not have jurisdiction to entertain it. Having so found, it means that the decision of the trial court is abhorrent and therefore the appellant is not entitled to the remedies it had prayed for. End of quote. Turning now to own costs, the trial court directed each party to bear its own costs. By dint of Rule 127 of the rules, courts in any event, in any proceedings, shall follow the event unless the court shall, for good reasons, otherwise order. The general rule is therefore that a successful party is entitled to costs and the losing party pays costs, unless the court is satisfied that there are good reasons to depart from the general rule. The court must bear in mind, among others, the conduct of a party in determining whether there are good reasons to depart from the general rule on costs. In Johnson Accord Umunyokoro versus the Attorney General of the Republic of Uganda, application number 10 of 2022, in paragraph 51, where the court stated that, I quote, taking the history of this litigation into account, the numerous and meritorious applications and appeals whose combined effect has been to delay the hearing and determination of the reference before the trial court, we do not see any good reason to depart from the rule that the costs follow the event. Accordingly, we award costs of this application to the respondent. End of course. The same reasoning for awarding costs to the winning party was advanced in Dr. Margaret Ziwa, the Secretary General of the East African Community, EACJ Appeal number 2 of 2017, where this court held that, I quote, costs are the discretion of the court, that in exercising such discretion, the court bears in mind that costs follow the event, and that a successful party may only exceptionally be deprived of costs, depending on the particular circumstances of the case, such as the conduct of the parties themselves or their legal representations, the nature of the litigants, the nature of the proceedings, or the nature of success. End of quote. Coming back to this appeal, we take into account the conduct of the appellant of trying to pursue a matter that has been taken by event many years ago through the back door and under the guise of a claim against the Ombudsman's refusal to review the decision of the Supreme Court of Rwanda. In those circumstances, we are satisfied that there is no good reason to depart from the general rule that costs follow the event. Accordingly, we award to the respondent state costs of this appeal and the costs of the reference in the trial court. Disposition, finally. The upshot of our consideration of the appeal is that, 1, the appeal be and is hereby dismissed, and 2, the appellant should bear the costs of the appeal and the cost of the reference in the trial court. It is so ordered, dated, delivered, and signed in Kigali on this 28th day of February 2025. And this marks the end of our.
Most obliged, my lords and my lady.
Maître Nicolas tujya gutangira urubanza rero rwarimo kubera mu rukiko rwa EACJ rugeze ku musozo aho urukiko rwanzuye yuko umunyemari Mironko François Xavier atsinzwe muri uru rubanza rwari rumaze imyaka irenga 30 aho yaregaga leta y'u Rwanda kuba hari amafaranga itamwishyuye agera kuri miliyari 18. Ayo mafaranga rero nk'uko byagarutsweho mu mizi ku rubanza rwagenze nuko ayo mafaranga yaguzwe intwaro ndetse yagurwa n'imyenda ya gisirikare yifashishijwe cyangwa se yatanze hagati y'umwaka w'1993 ndetse n'1994 ariko akavuga yuko ayo mafaranga atigeze ayishyurwa. Hanyuma rero urukiko rwanzuye yuko uyu munyemari Mironko François Xavier atsinzwe ndetse rumutegeka yuko hari amafaranga agomba gutanga yose yagenze kuri uru rubanza kuva rwatangira. Ariko ntabwo nakwizimba mu magambo, turi kumwe n'umwunganira leta y'u Rwanda, uyu ni Maître Nicolas. Maître Nicolas ashobora kuza akatubwira ese ubundi bashingiye kuki bavuga bati Mironko aratsinzwe. Mironko mwongeye kwirirwa Maître Nicolas. Yego, hanyuma urukiko rumaze kwanzura yuko Mironko atsinzwe. Ese ingingo z'ingenzi zigendeweho bavuga bati aratsinzwe nizihe?
Ingingo ngira ngo nuko utakumwa kuri kibazo rwose. Uru rukiko ni urukiko mpuzamahanga, ni urukiko akenshi rugenda ku miburanire y'ababuranyi, icyo bita submissions, ibimenyetso batanze, ndetse hakanagenda ku amajuridanse cyangwa se decided cases, imanza bazaraciwe cyane cyane mu rukiko ndetse n'izindi manza n'izindi nkiko. Hari ibyemezo by'inkiko bisanzwe bihari byisanisha n'ibingibi n'urubanza. Bagiye bashyira ku manza nyinshi zagiye zicibwa mu rukiko zifitanye isano cyangwa zisa n'urubanza rwa Mironko, aho ababuranyi bagiye batsinda muri izo manza. Hakabaho principle cyangwa principe ivuga yuko muri no rukiko, muri rules cyangwa se amategeko agenga imiburanishirize y'imanza yo mu rukiko, ivuga yuko mu gihe ababuranyi baburana, utsinze n'ugomba kubona indishyi, keretse urukiko rubonye ko atari ngombwa cyangwa se hari ngombwa yuko igomba kwirengagizwa kugira ngo nubwo waba utsinze ntubone indishyi. So byose babisesengura, bakoze ubusesenguzi bw'urukiko, ubusesengura bw'abacamanza, basanga mu by'ukuri cyane cya mbere yuko uwatsinze in this case agomba guhabwa indishyi. Aya ni impamvu ategetse yuko agomba guhabwa indishyi arizo zitwa costs ku rwego rw'ubujurire ndetse no ku rwego rwa mbere, icyo bita that's the costs on the level of the appeal and the costs on the level of the reference. Uvuga ngo urubanza rwajuriwe tuzasaba duhabwa indishyi mu rubanza rwajuriwe, ndetse duhabwa n'indishyi mu rubanza urunguru rw'uyu munsi narwo rubaye dismiss cyangwa se rutakiri watsinzwemo. Icyo mu by'ukuri cyo bashingiyeho cyane cyavuga yuko ko twagumye kugaragaza mu rubanza rumaze imyaka myinshi, rwatangiye mu rukiko 2018, ariko mbere atsinzwe yanga kwemera ibyavuye mu rubanza, ahubwo ahitamo kujurira ndetse ati turaja mu bitandukanye n'ibigengwa n'amategeko, dutanga icyo bita application, saba yuko ujurire butakirwa, ikirego kirakirwa ariko n'umwongera akora indi application asaba yuko ubujurire bwakirwa, urukiko rwa lenient rwemera yuko ubujurire abutanga nyuma y'igihe gitegwa n'amategeko. Byose babivuze mu judgment babivuze. Hanyuma maze kwakirwa biba ngombwa yuko n'umuhaga gusija urubanza, tujya mu nama ntegurarubanza y'icyo scheduling conference muri system za hano. Scheduling conference naho mwemeranya ku bigomba kuburanwa cyangwa bigomba kumvikanwaho, bigomba gushyirwa imbere y'abacamanza mu nteko iburanisha. Byaragenwe rero byumvikanaho, ariko cyane kigamijwe no kwemeza yuko ese mu by'ukuri koko urukiko rw'ibanze cyangwa se muri first instance division rwaba hari amategeko rwishe mu kwemeza yuko Mironko yatanze ikirego akererewe. Kuko twagaragaza yuko mu by'ukuri muri tegeko hano article 30 paragraph 2 ya Treaty of the Establishment of the South African Community ivuga yuko umuntu wese utanga ikirego mu rubanza mu rukiko agomba gutanga ikirego mu gihe kitarenze amezi abiri, era mu gihe amaze kumenya yuko ikoze icyo bita cause of action cyangwa subject matter ibaye, agomba kugitanga mu gihe kitarenze amezi abiri. Amezi abiri byaba atakimenya no mu gihe kibaye there's action, the action of the action, cause of action, hakaba na knowledge cyangwa se kumenya igihe icyo kibazo cyabereye. Ushobora kuba ntukimenya.
Yego.
Icyo gihe bashaka kureba muri ambit yuko igihe cyabereye cyangwa se ukareba mu gihe wabimenyeye, byose birarebwaho. Noneho bigagaragara yuko mu by'ukuri kuko yaraje gutanga ikino kirego avuga yuko Leta y'u Rwanda yanze kumwishyura, yatanze mu rukiko rw'ubucuruzi, ayitanga mu rukiko rw'ubucuruzi, agera mu rukiko rw'ikirenga ndetse agera no ku rwego rw'umuvunyi. Aho hose rero ni imyaka myinshi yatambutse, ari tukagaragaza yuko mu by'ukuri kuba yaramenye yuko Leta wenda itari bumwishyure cyangwa se yavuze ko itamwishyura nk'uko bigaragaza, yabimenye imyaka myinshi itambutse mu gihe yatangaga ikirego mu rukiko rw'ubucuruzi. Twagaragaza ko mu gihe urukiko rw'ubucuruzi rwagaragaza yuko Leta ivuga ko bimwishyure, yagomba guhita atanga ikirego mu rubanza mu rukiko, kuko mu rukiko rwo hari principe ivuga yuko ntabwo ufite requirement icyo bita exhaustion of all remedies nko mu zindi nkiko mpuzamahanga. Mu zindi nkiko mpuzamahanga nyinshi usanga yuko ari itegeko ivuga yuko kugira ngo ujye mu rukiko ugomba kubanza kuburana mu nkiko zose zo mu gihugu, icyo bita exhaustion of all remedies. Rero muri East African Court of Justice sose ko bimeze, umuturage cyangwa umuturanyi wese yemerewe kuza directly agahita atanga ikirego atagombye kubanza gukora exhaustion of remedies. Kuba rero yahisemo kubanza kunyura muri zino nkiko zose akabanza kuzitura zose ndetse akajya no ku rwego rw'umuvunyi, ni ukuvuga yuko yari afite uburenganzira bwo kubuza direct mu rukiko, ariko bahise muri ya nzira byamubuje amahirwe yo kuza ku access mu rukiko. Twe n'inzitizi twatanze rero tuyigaragaza mu burane yacu kuva mbere, tugaragaza yuko yagomba kuba yaje mbere, ariko mu gihe yahisemo iriya nzira yo kubanza kujya mu zindi nkiko byamubuje amahirwe yo kuza mu rukiko. Urukiko rero rwasuzumye imyanzuro yacu n'inzitizi twatanze, rwemeza yuko mu by'ukuri amezi abiri ateganywa n'itegeko under paragraph 30 paragraph 2 of the Treaty for the Establishment of the South African Community atayubahirije. Bityo urukiko rwiyambura ububasha bwo kunesha urubanza. Rwiyambura ububasha rero arajurira. Urukiko rw'ubujurire rusuzumye rusanga mu by'ukuri urukiko rwa mbere cyangwa the first instance division nta mategeko rwishe, kuko to appeal here n'ubanza kugira ngo utange ubujurire, it is under article 35A. Ugomba kugaragaza either urukiko hari amategeko rwirengagije, ese urukiko hari ibimenyetso rwirengagije, cyangwa se mbese ntabwo uri upfa kuza gusa kuko ngutanyuzwe n'imikirize y'urubanza. Ugomba kuba uri muri izo ugaragaza ati urukiko rwirengagije amategeko n'aya, urukiko rwirengagije ibimenyetso ibi n'ibi, cyangwa se urukiko hari indi mihango rutubahirije mu miburashire y'urubanza. Ibi byose urukiko rwabisomye usanga mu by'ukuri byarubahirijwe, bityo rwemeza yuko nta kosa urukiko rwakoze mu kwemeza yuko urubanza rujurirwa rwari rwatanzwe nyuma y'igihe giteganywa n'amategeko. Anayo mpamvu urukiko rushingiye ruvuga yuko ikirego kidashobora kwakirwa, ndetse rusanga ari na ngombwa mu gihe Leta y'u Rwanda itsinze mu rubanza igomba guhabwa indishyi kuko twabisabye mu biraniro. Twasabye indishyi kuko twagaragaje yuko mu by'ukuri dukeneye indishyi kubera ko twakorewe mu manza ku mpamvu z'amaherere. Urukiko rwo mu by'ukuri urukiko twabona ko rwandiriye, we are very happy. Iyo uburanye urubanza ugatsinda urishima bien sûr. Akazi kacu twakoze neza kandi twabyaye umusaruro. Imyaka kuva 18 turi mu rukiko, ni ukuvuga ngo hose twadepasaga, dutega indege tujya Arusha, tujya kuburana, dufarira byose n'amafaranga Leta tugendaga tujya kubona urubanza bitari ngombwa, tubona ko bitari ngombwa. Bityo tugasanga yuko kuba rero urukiko ruciye urubanza rukemeza yuko imiburanire yacu ifite ishingiro, ndetse rukamenya no kuduha indishyi, turabyishimiye cyane.
Hanyuma ubwo indishyi ingana ite mugereranyije?
Genda bivuga nyine ahangaha byumvikana yuko ndavuga nk'umwavoka, ntabwo mvuga nk'umuhagarariye Leta, yagenda nk'umwavoka mu rubanza nyine ko mwanuze bikora ntabwo nabigeza. Ariko indishyi zo uko bigenda hano muri procedure hano mu nkiko za hano tumenyera yuko iyo urukiko rutanze indishyi rugaragaza n'umubare w'indishyi, ariko muri procedure hano ntabwo rukomeze. Iyo uvuze ngo cost hari icyo bita bill of cost, ni ukuvuga ngo icyo gihe iyo usaza ari ngombwa cyangwa ushatse uvuga ari nk'uwatsinze ukora icyo bita filing a bill of cost. Bill of cost nacyo ni ikirego ukwacyo, ikirego ukwacyo utanga mu gihe giteganyijwe n'amategeko, ugakora bill of cost ugaragaza amadepanse yose wakoze, ugaragaza n'ibimenyetso, ugakora icyo bita bill of cost, ugakora quotations ukayitanga mu rukiko, ugaragaza umubare w'amafaranga haba amadolari cyangwa haba amafaranga bitewe na kare sa kenshi twabara amadolari ko n'urukiko international ntabwo haba amafaranga, ntabwo tubara amadolari. None ugaragaza bill of cost ugaragaza amadepansi yose watakaje, usaba ko urukiko rwategeka ayo mafaranga watsinzwe ayagusubiza. So ubwo n'ubwo ngo rero by'ukuri ubwo tuzareba niba ari ngombwa gutanga bill of cost, ubwo bizaterwa nuko abayobozi basanga ari ngombwa.
Leta izabyanzura.
Byose ubwo n'ubwo kuko hari ahandi ndabura nuko mfite abanyobora. Ubwo abanyobora nasanga ari ngombwa gutanga bill of cost tuzayitanga. Niba sanga ko atari ngombwa ubwo nabyo bazabisuzuma kuko tugenda ku mabwiriza y'abayobozi bacu ko byagenda ko ndi hano manaje guhagarira intumwa nkuru ya leta mu rubanza, ariko n'uvuga ngo rero bagomba gutanga raporo y'uko byagenze iyo nakoze akazi kanjye n'abayobozi bakatubwira icyo tugomba gukora.
Murakoze cyane Maitre Nicolas.
Murakoze cyane.
Hanyuma rero nk'uko mumaze kubyiyumvira nuko urubanza rugenze, nuko imikirize y'urubanza igenze, ku ruhande rero rw'uyu munyemari Mironko François Xavier ntabwo umwunganira twabashije kumuvugisha kuko urubanza rukimara kugera ku musozo, rukimara gupfundikirwa yahise agenda, ntabwo twigeze tubasha kumenya mbese uko biyumva, ariko byanga byakunda uko biyumva ntabwo ari neza kuko iyo utsinzwe nyine ntabwo wishima. Ubwo rero murakoze cyane, reka dushimire abantu mwadukurikiye kuri YouTube channel ya Kigali Today ndetse no ku mbuga nkoranyambaga zacu, mukomeze mudukurikire, murakoze.